veto rights as well? I mean,
veto rights.
Running into a bunch.
Give me an example.
Series A or Series B is required to approve any sale of the company. You may be on Series F. Somebody forgot to go back and fix that on Series B.
So Tim was a principal in one of the major venture capital firms here in the Washington, D.C. area for many, many years. And when venture capitalists come in or investors come in, there may be various tranches of investment, right? Series A is the first round, Series B. I've done Series G rounds and Series H rounds, and some of them are called down rounds because they buy in. There are all kinds of provisions in these agreements that would give the investors, the owners of the company, the right to veto the transaction from the very beginning. If you have that type of a capital structure, beware. It's not typical in most of our entrepreneurs because we don't go out and raise outside equity. But if we do have a company that's raised outside equity with private equity or venture capital or angel investors, we will see these types of provisions in their contracts. In any event, these are the things we're looking for in due diligence. And there are different types of due diligence reviews. The most comprehensive one is where the buyer says to the lawyers and the diligence team, which will include the accountants, which may include technology experts, if there's technology involved in the transaction, which may include government contracts experts in the field. They will go in and prepare a report back to the buyer saying, here's what we found, and here are the issues. Here are the warts that we found when we looked under the tent, so to speak. That's the most comprehensive. But it's still a good idea to document in due diligence from the seller's perspective as well. If the seller tells the lawyers to conduct due diligence, and the seller's counsel convinces the seller that they should do that, then there should be some documentation of what they found and what the issues are. Because all of that's going to wind its way into the reps and warranties and into what's called the disclosure schedule that's attached to the purchase agreement, which may be 10 times the size of the purchase agreement itself. Where do we find all this information? Everywhere. But some of the more innocuous places are on the internet. With the ubiquitousness of the internet, ubiquity of the internet, we can go out and find stuff on our clients or our prospective sellers that you would be shocked. And on their website, it may say stuff that's inconsistent with the executive presentation that was made by the investment bankers. I've seen that happen, which is inexcusable. They should have corrected that ahead of time. So it's everywhere, including the disclosures, the oral disclosures. So if you're a good salesperson and you're selling the company, that's great, but you better have backup for your position. That's really what it boils down to. So these are the sources. How do you manage the process? In the old days, we used to have a big room that had tons of binders in it that had everything in it organized. We called it the data room. Today we have virtual data rooms in almost every deal. We want to make sure, because of security concerns particularly, that the data room is populated with only that which it can be populated. So if we have IC community, intelligence community contracts, we are not allowed to post those to the data room. In fact, the buyer is not allowed to see a lot of these contracts. I have one deal going on right now where we've got an NSA contract, and there's no way that the buyer is going to see it. Can't. We can't even identify who it is that we're contracting. So the data room will be done digitally, and there are different sources of that, different websites, different firms that have the ability to offer that. They charge for it. We actually have created data rooms in some of the smaller deals for our clients using a secure encrypted website, and we build the data files for the data room using diligence checklists that are presented by the buyer. And then we manage the disclosure. So as I had mentioned, you may want to set up milestones in your letter of intent that says, I'll disclose this to you after you do this as part of the transaction, which incentivizes, and if they don't do it by a certain date, the exclusivity provision that said we aren't going to negotiate with anybody is over. Now in some deals that are big enough and warranted, we may have a breakup fee. There may be a fee that gets paid to either the seller or the buyer if either party doesn't go forward for a particular reason. And whether or not that's appropriate in a deal depends on the deal. But it's a way of incentivizing people to go to closing. Whether you need a breakup fee is really a case-by-case basis. And these are the areas of diligence really which map in very close context to what's in the acquisition agreement, which we're going to talk about in a second. But some of the things that are really not in the acquisition agreement are making sure that we've got adequate controls and processes in place, accounting controls and processes. But everything else is pretty much covered under the acquisition agreement.
One that I see people miss a lot is intellectual property and trade secrets. And by using the opposing party's attorney to do that work, makes all of your intellectual property and trade secrets available to the client. So most of the time what we do is recommend that they pick a independent party to review the patent filings, the code base, trade secrets, and the rest, so that if the deal does fall through, especially if it's a strategic buyer, you're not at risk of your potential buyer competing with you the next day.
Yeah, it's tough, because at some point you got to close the deal, right? So they're going to have to find out about it at some point.
But giving them the code base never makes sense.
I never give them the code. So if there's software associated
with patent filings,
I mean, Updata was very involved in the software companies and products. Absolutely. Anything that's patentable, even that hasn't been patented, anything that's, trade secrets are squishy because it's a very broad definition, and it may cover stuff that's not patentable. It may cover stuff that's not covered by copyright or trademark protection. But it still is very valuable to the company. And it could be a process that is short of being patentable, but it's really, really key to the success of the business, whatever that may mean. And so protecting that process, protecting the code is absolutely critical.
Just to
Question?
clarify, Tim, you were saying is an outside third party would assess those types of things?
Like there's a firm that does all this work for Cisco and Oracle as an example.
Right.
Everybody's comfortable with that firm doing it. They're highly respected, and for the most part, this seller engages them. So if the deal doesn't go through, then the seller still has the relationship.
So what the technology expert's going to do is verify the existence of this stuff and verify its capability.
And there's no open source or other people's product in it, things like that.
Exactly. And that way you protected the sanctity of the stuff that you're really trying to protect. We've engaged that in technology deals where there's true technology to protect. Let's move on. Let's get to the acquisition agreement, because that's really the core of the deal. And when we're doing anatomy of an acquisition or anatomy of a merger, and by the way, I stole that title from James Freund, who was he's still alive, but he was with Wachtell Lipton, which is one of the great M&A shops out of New York. And he's probably the father of M&A, as far as I'm concerned. I mean, he wrote this book, Anatomy of a Merger, back in the 70s. And when I worked for Venable back in the 80s, Jack Schlanger, who I worked for, handed me this book and said, "Read this." And that's all he said. And so I read it, and at the time, all of the stuff in there was really applicable. Today, half of the book is not applicable because it's dealing with tax issues that have changed, and they haven't updated the book. But the first half of the book is all about his theory of negotiating, and then he wrote a book called Smart Negotiating after that in the 1980s, and it's something that everybody should read. His last name is spelled F-R-E-U-N-D, and you don't have to get it because I have the books at home. So, but those books are really, really valuable tools in understanding how M&A transactions can unfold and some of the issues that come up in the M&A transaction context. So the acquisition really is broken down into four main areas in my view. It's the purchase price consideration, how it's paid, what's held back, the structure of the deal, the reps and warranties that are given by the seller and the buyer. The buyer actually gives reps and warranties. And if you get equity from the buyer, if you get a stock interest from the buyer, then you want to do some due diligence on your buyer. You want to understand what you're getting. If it's a public company, well, we've got a lot of information available through the public disclosures made available to everyone. But if it's a private company, which in many cases it is, what are you getting? And that's always been my difficult task as seller's counsel or a founder's counsel in the context of getting information from the private equity firm that is going to be giving them equity in their company going forward, which may be a roll-up of a variety of different companies into a single entity. What are their rights? What do they get in the long term? What happens if they leave? What happens if they're terminated? All of these things come into play when you're getting equity in a buyer side transaction. So the reps and warranties, conditions to closing, the covenants that have to be given by the seller usually in terms of the getting to closing, and then after closing, what do they have to do or what can they not do? And then indemnification and limits on liability, which are really important.